Assalamu alaikum and welcome to another episode of DigiPod on DawnNews English. I'm your host Usama Khilji, and today we're going to be talking about the Prevention of Electronic Crimes Act 2016, which is also known as the Cybercrime law in Pakistan. So why is this law relevant today? We've been hearing a lot of cases filed against various members of society such as lawyers, academics, journalists, and everyday common citizens as well as politicians being charged under this law, spending a lot of time in jail for it, before detention, and some convictions as well. So in light of all these news reports, we've also seen that the law has been challenged in various high courts around the country. And not only PECA law, also the Punjab Defamation law. And both these laws essentially have been challenged because of their alleged violations of fundamental human rights that the Pakistani Constitution guarantees. So we'll be talking about this. We'll also be talking about how this law potentially violates the Constitution of Pakistan, as well as the international law obligations of Pakistan as we are signatories to the International Covenant. To talk about this and a lot more, we're joined by two lawyers. We're joined by Rida Hussain, who's an advocate of the High Courts. She's also a constitutional law expert. Thank you very much for joining us, Rida. And we're also joined by Noorzadeh Raja, who's a human rights law expert with years of experience dealing with international human rights law issues, and she's also spoken at the United Nations Human Rights Council. So thank you, Noorzadeh. We'll start with Rida Hussain. So Rida, if you could please tell us, in light of the Constitution, especially the fundamental rights guaranteed to Pakistanis in the Constitution, how does PECA potentially violate that? And especially, in light of the 2025 amendments to PECA, which we saw come about last year, and we've already seen convictions under them. Over to you, Rida.
Thank you, Usama. Usama, when we talk about the Constitution of Pakistan, the most fundamental right when it comes to the Prevention of Electronic Crimes Act is Article 19 of the Constitution, which relates to freedom of expression and a free press. Now, Article 19 of the Constitution does contemplate that there can be reasonable restrictions on freedom of speech, but the courts have interpreted this to mean that the reasonable restrictions are to be interpreted narrowly. The reasonable restrictions are to be interpreted in a strict manner, and you can't use the reasonable restrictions in a manner so as to violate the right and then say that actually this is a reasonable restriction. And when it comes to the Prevention of Electronic Crimes Act, you spoke about the amendment last year, which I think is really fundamental. It came in January of 25 last year. And at the time when they were bringing the amendments in debates in Parliament, you had parliamentarians saying that there's a lot of fake news in Pakistan. And, that's why we need to amend this already very oppressive law. And they introduced a provision, which is Section 26A. Which relates to the spread of fake or false information. At the time, journalists and rights groups said that this provision, Section 26A, will be used as a tool to suppress dissent, to suppress criticism, and to suppress journalism. And basic questions that you ask the state will be clubbed as fake news, and that's what we've seen happening. So the greatest way, in my view, to see whether a law violates fundamental rights is to see how has it been applied since it's been enacted. So you have human rights lawyers, Iman and Hadi. The case against them also included Section 26A. One of the provisions they've been convicted of is Section 26A. Then you have Hamza Ahmed Khan, who is a PhD scholar from Canada, who was visiting Pakistan and, as per reports, was conducting research for his project in Pakistan. And the case against him also invokes 26A. And then you had Saurabh Barkat, who is a journalist. And his case, for me, is the most dangerous case when it comes to journalism, because one of the FIRs in Saurabh's case said that he interviewed Sanam Javed, and by virtue of interviewing her and being the host of that interview, he participated in disinformation and the spread of false news. So the way that the state is interpreting Section 26A is that if you're a journalist and you're even conducting an interview, that can also be classified as per the state as fake and false information.
Absolutely. And Rida, what you're describing really shows us how vague the language of this law is. And also, the major issue is that the state is now becoming a party, and the state, through the National Cybercrime Investigation Agency, is filing cases against activists, against lawyers, against academics, its own citizens, saying, you have offended me, and because I'm offended, you will go to jail. I will file a case against you, and use the system, to ensure that that happens. And that's what we've seen in all these cases that, Rida, you've just talked to us about. So I'm also wondering, what are the procedural issues that exist with PECA? Apart from what you described as a violation of Article 19 of the Constitution that guarantees freedom of speech and expression and press freedom to Pakistanis. So how is PECA, what are the procedural issues in it? Yeah.
Osama, I'm so glad that you spoke about criminalization of defamation, because if we look at international jurisdictions like the United Kingdom, they've actually decriminalized criminal libel. And there's a conversation now globally as well about how defamation should not be a criminal offense, and any liability that there should be within the civil law, whereas in Pakistan you have criminal defamation laws. The other interesting aspect is that Justice Athar Minilla, when he was a judge of the Islamabad High Court, he passed a judgment in which he actually struck down Section 20, part of Section 20 of PECA, which related to the harm to reputation part. And he said that it would have a chilling effect on free speech. And what you said is absolutely right, that the purpose of defamation laws is to protect individuals. The military or the judiciary are not individuals, and you cannot use defamation laws to shield state institutions from criticism, because, as you very rightly said, that the purpose of defamation laws is to protect individuals. It is not to protect institutions or to shield state institutions from criticism. And so I think that Pakistan needs to also, and the conversation needs to move towards decriminalization of defamation, as opposed to including more offenses when it comes to advocating for speech. When you talked about the procedural issues, I think that each case that we talked about had distinct procedural issues. So when it comes to Hamza Ahmed Khan's case, we saw that his bail was denied by two forums. Two courts have denied his bail so far for PECA-related, speech-related offenses. And as at the date of recording this podcast, as far as the information I have, he's still in jail for speech-related offenses. And the Code of Criminal Procedure says that if an individual is accused of an offense which relates to punishment which has death, life imprisonment, or it has a 10-year sentence, then that is called the prohibitory clause. But Hamza has been accused of an offense where none of those provisions apply. And interestingly, the judge in Hamza's case acknowledges that the prohibitory clause doesn't apply, but he says that Hamza's posts were so gruesome that he is going to deny him bail anyway, even though the defense presented case law which clearly said that bail is the rule and refusal is the exception. So we see a clear violation in cases of PECA of the right to liberty as well. That even when the law says that bail is the rule and refusal is the exception, we see courts routinely denying bail. And in Hamza's case also, the order, I feel it's such a violation of free speech, because it says that his posts were gruesome and that he was targeting the civil and military hierarchs of the country, and therefore he's being denied bail. And even if we look at Sorab's case, Sorab was in jail and for months before he got bail. And so we see a
3
clear
months.
violation. Yeah, we see a clear violation of the right to liberty in cases where there's effectively pre-trial detention without a trial, without a conviction, and essentially FIRs upon FIRs are registered and people are kept behind bars. In Iman and Hadi's case, we saw a distinct aspect of procedural violation. In their case, we saw that there was a fast-track way in which the trial was being conducted. There were day-to-day hearings. There were multiple witnesses being cross-examined in one day. There was a defense counsel that was forcibly imposed on Iman and Hadi. And again, we saw that the the law PECA was used in a manner to deny them their right to a fair trial and due process, and to continuously deny them, because now even their appeal is not being heard, despite the fact that it has been over 60 days. So you see that the right to a fair trial and due process, which is in Article 10A, the right to liberty, how all these different fundamental rights, how in practice, in real life cases, in real life examples, they are being violated and they continue to be violated.
And speaking of violations, Rida, you've told us, the constitutional issues with this law, but I'm also wondering, we have the GSP Plus status handed to us. It's a treaty sort of between the EU and Pakistan, in which the different conditionalities, where tariff concessions are linked with Pakistan's human rights improvements. We've also heard from the business community saying that if Pakistan was to lose the GSP Plus status, which happens if Pakistan doesn't perform well in its human rights obligations, international law obligations, then it'll have a huge economic cost. So Rida, maybe you could run us through what GSP Plus status entails, what does it mean, and how it impacts the human rights performance of Pakistan, and how the state or the government is a policy towards human rights really are.
So, Sama, the GSP Plus status essentially requires Pakistan to comply with 27 core international conventions, which include the International Covenant on Civil and Political Rights, the Convention Against Torture, Inhumane and Degrading Treatment, and it links certain trade benefits, economic benefits to Pakistan complying with its international human rights obligations. Now, periodically, the EU also conducts reviews and monitoring missions about whether a state is complying with its human rights obligations or not. So, over the course of the last few years, the EU bodies, the EU monitoring missions on different aspects have been raising concerns with Pakistan when it comes to its human rights record. And we've talked about pre-trial detention. That is something that has also been raised, freedom of speech.
And where does PECA come in?
So PECA comes in when it comes to like free speech and the International Covenant on Civil and Political Rights. And when you talked about the state getting offended, the important thing in my view is that the onus is not on those that are raising human rights violations. The onus is on the state to ensure that it is complying with its human rights obligations. And recently we've seen a lot of discourse about the fact that raising these issues is actually being considered anti-state and being considered treasonous, whereas it is the state's obligation and it is contingent upon them complying with these obligations that Pakistan has this status. So I think that we need to change the narrative a little bit in terms of the fact that the onus is not on us as citizens or those who are aggrieved by human rights violations. The onus is on the state. These are the state's obligations, and it is also a mechanism for accountability. And when it comes to international obligations, a very good example is the United States. I know that recently the United States has also not had a very good record when it comes to free speech, but there's a case in the United States, which is New York Times versus Sullivan, which says that when it comes to free speech, if you are accused of defaming an individual who is in public office or a public office holder, the standard is much higher versus if the person on the opposing end is an ordinary citizen. And the test that they've developed is actually called the actual malice test. So if you speak against a public official, you can only be proceeded against if it can show that you had actual malice. So the standard when it comes to defamation claims for public officials in international jurisdictions and as per global jurisprudence is that there is a higher standard. And the logic for this is very clear in my view. It is that when you enter public office, you are more susceptible to criticism. There are often sharp attacks at the government, at government policy, at government ministers, and the limits of acceptable speech when it comes to those in public office must be higher than those of ordinary individuals.
Yeah, Rida, speaking of public officials, in Pakistan's largest province, Punjab, we also have the Punjab Defamation Law, and it also mentions public officials. Is there a different threshold? Should they be, protected more, or are they protected less, like you mentioned in the case earlier, the New York Times case? So what does the Punjab Defamation Law say? Are public officials, are we allowed to criticize them more?
So the Punjab Defamation Act actually does the exact opposite, and it's also been challenged in the Lahore High Court. You're right, it defines constitutional office holders, public office holders, including the Chief of Army Staff, the Chief Justice, various parliamentarians are defined as constitutional office holders. And interestingly, it makes it easier for them to file defamation claims against citizens because the Punjab Defamation Act says that if a constitutional office holder files a defamation claim, they don't even have to personally appear to file it. So the way that I view the Punjab Defamation Act is that you're actually making it easier for public officials and constitutional office holders to sue citizens and to file defamation claims against them. And that defeats the exact purpose of the New York Times Sullivan case, which we talked about, that there must be a higher standard when it comes to public officials. And the Punjab Defamation Act, the way that even procedurally it is defined, it even contains provisions which relate to an effective gag order preventing people from talking about pending proceedings. It allows the government to be involved in the establishment of the tribunal, which is also problematic because often speech is directed towards the government. So if the government itself is involved in the establishment of a tribunal in a case where the content which is being questioned or the content which is alleged to be defamatory is against the government or government ministers, there is a question about the independence of those tribunals.
So what we're really seeing is that the state is becoming the judge, the jury, and the executioner in so many aspects of the criminal justice system, which puts under question the independence of the judiciary and the separation of powers in the state. So we'll move over to Noorzadeh Raja, who's here with us. Thank you for joining, Noorzadeh. And essentially, maybe you can walk us through what are Pakistan's international human rights law commitments, and especially when it comes to the PECA law, the Prevention of Electronic Crimes law, and its speech-related aspects.
Thank you so much, Usama, for the question. I want to preface my response by saying that I think what we're witnessing in Pakistan currently in real time is the complete disintegration, and I would go as far as to say desecration of all fundamental rights that are necessary and intrinsic for any meaningful exercise of any kind of democratic and civic participation. And I think freedom of expression is really the cornerstone of all of those rights, because any related right, like the right to freedom of assembly, the right to freedom of association, is inextricably connected to the exercise of the right to freedom of expression. And I think it's exactly this kind of scenario in which international human rights law has resonance and relevance, because the purpose of IHRL inherently is to protect our rights as individuals and as citizens. So even when a regime becomes repressive and authoritarian and seeks to restrict these rights in practice by amending domestic legislation, there still remains a layer of scrutiny, redressal, and rectification that's available at the international level if the regime in question has ratified international human rights law treaties and covenants. I want to first talk about the International Covenant on Civil and Political Rights, which Pakistan ratified in 2010. So when any government signs and ratifies an international human rights law treaty or covenant, that process of ratification creates a binding legal obligation. So the government of Pakistan has an obligation under international law to respect, protect, and fulfill all of the rights that are contained within the covenant and to implement them domestically, and also to bring local laws in Pakistan in conformity and compliance with the covenant. What is most relevant for the purposes of an examination of the right to freedom of expression is Article 19 of the International Covenant on Civil and Political Rights. So Article 19 states very, very clearly and emphatically that every individual has the right to freedom of expression under international human rights law. And the covenant is very clear that this right shall include the freedom to seek, receive, and impart information and ideas of all kinds, either orally in writing or in print or through any other media of the individual's choice. And I think it's very, very relevant here to emphasize that there are only two scenarios or two conditions in which this right can be limited or restricted. And these two conditions have also been set out within Article 19 of the Covenant. So the first is that such restriction may be provided only by law and as is necessary for the respect of the rights or reputations of others. And secondly, such restriction shall only be as provided by law and as is necessary for the protection of national security or of public order or of the public health or morals. I think given that the language of the covenant is quite general in nature, it's very important to look at the guidance that has been issued by the United Nations Human Rights Committee in relation to what exactly the parameters and contours of such restrictions can reasonably look like. And in order to do that, I think that it's very important to look at General Comment number 34, which was issued by the UN Human Rights Committee to delineate the scope of Article 19 in practice and how states should be applying it in order to comply with the covenant and what constitutes reasonable restrictions on freedom of speech and expression. So the first thing that's relevant here is that the UN Human Rights Committee has stated emphatically that any such restriction has to conform to the strict tests of necessity and proportionality. So restrictions can be applied only for those purposes for which they were prescribed, and they must be directly related to the specific need on which they are predicated. So the objective has to be clearly specified and identified, and the restriction that is introduced cannot be in excess of that objective. So this test has been laid out very clearly by the UN Human Rights Committee. And I think it's very important here and very relevant also, given that there has already been a discussion of the case of Iman Mazari and Hadi Ali Chattha, that 5 United Nations special rapporteurs, including the special rapporteur on the freedom of expression, have highlighted that the PECA charges arising from Iman and Hadi's social media posts do not fall within the sphere of ICCPR exceptions as articulated in the covenant and as articulated by the UN Human Rights Committee in accompanying guidance. So it's very clear that the manner in which PECA is being applied currently in Pakistan to stifle critical dissent, to clamp down on dissenting voices, to clamp down on human rights defenders and political dissidents, certainly contravenes the sphere of exception articulated by the UN Human Rights Committee, as well as that contained within Article 19 of the Covenant. And the committee has also been very clear in stating that such restrictions can never be invoked as a justification for the muzzling of any advocacy of multi-party democracy, of any democratic tenets and human rights. So again, the manner in which PECA is currently being applied in Pakistan contravenes the conception of those exceptions as formulated by the UN Human Rights Committee. The committee has also stated, in addition, that national security laws cannot be invoked to suppress or withhold from the public information of legitimate public interest that does not harm national security and cannot be used to prosecute journalists, researchers, environmental activists, or human rights defenders for having disseminated such information. So I think in line with Article 19 of the ICCPR, as well as accompanying guidance issued by the UN Human Rights Committee, it's very clear that the broad and vague definitions currently within PECA of terms like aspersions, false information, and unlawful or offensive content under the most recent amendment fail to meet the necessity and proportionality test as laid down by Article 19 of the ICCPR. And in effect, what has happened in Pakistan is that by criminalizing aspersions against state institutions, including the judiciary, the military, and parliament, what is happening in practice is that PECA is actively being used to suppress political dissent and public debate, which inherently contravenes international free speech protections. And in practice, such a law then serves as a legal tool to silence journalists, human rights defenders, and all political dissidents who may be critical of the existing regime. And again, these concluding observations are binding and create an additional legal obligation on the state in question. So in relation to Pakistan, Pakistan was reviewed by the UN Human Rights Committee most recently in December of 2024. And the Human Rights Committee, in its concluding observations that were issued to the government, stated very clearly and very expressly in relation to freedom of expression that the committee is concerned about the chilling effect that criminal defamation laws and legislation like PECA have had on the exercise of freedom of expression by journalists, activists, human rights defenders, and members of ethnic and religious minorities. And the UN Human Rights Committee, in its concluding observations, urged the government of Pakistan to take immediate steps to ensure that every individual can exercise the right to freedom of expression online and offline without interference including by reviewing or repealing the legislations that have been mentioned by the committee. And the reason why this is important for Pakistan's next state review by the UN Human Rights Committee, which will now be in 2029, is that it's very clear that the new insertion, which has come about in PECA as a result of the 2025 amendment, which has inserted Section 26A, which essentially criminalizes dissemination of false and fake information, contravenes not only Article 19, but also the 2024 concluding observations. And again, as I've said, in Pakistan's next state review, the committee will look at the extent to which the government of Pakistan has implemented the concluding observations that were issued in 2024. Because what this process of review is essentially meant to do is that it highlights what the gaps and flaws are in any state's implementation of the covenant in question. So the UN Human Rights Committee, I think, is very clearly delineated and articulated what the gaps are in Pakistan's compliance with Article 19. It's very clear that the newest amendment to PECA only expands the sphere of the state's intrusion into and regulation of the freedom of expression and freedom of speech. And it's very clear that the newest amendment represents backsliding. So it takes Pakistan one step further from complying with its obligations under Article 19 of the ICCPR.
So thank you to our guest today. Rida has walked us through what the constitutional law in Pakistan says about fundamental rights that the Prevention of Electronic Crimes Act, the PECA law, may be violating. And we've heard from Noorzadeh Raja on Pakistan's international human rights law obligations and how under the UN mechanisms and also the GSP Plus status that the EU has given Pakistan, how PECA and other laws could potentially land us in trouble within those mechanisms. So it's all the more imperative that in Pakistan, rule of law is upheld, laws are legislated, implemented, and accounted for, but also oversight of these laws takes place in a transparent manner. And as long as we have that, there's also economic consequences if these rights are violated. We've heard about the GSP Plus status, and we've also heard about our periodic reviews with the United Nations. But even other than that, just preserving the dignity of every Pakistani citizen as the constitution demands, and ensuring that the economic well-being of citizens as well as their basic rights to speech, to express their opinions are safeguarded is very important. So that's all for today. Thank you very much for joining DigiPod on Dawn News. This is your host, Usama Khilji, and we'll see you next Wednesday with another episode.